Hello, welcome to my channel. Today, we are going to study criminal law for the uniform bar exam. We are going to study some questions related to larceny, robbery and attempt. Prior to the question, let's learn the rules related to the first question. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. The intent to permanently deprive must be present at the time of the taking. Now we are going to read the first question. Jack and Jill were co-workers. Jack admired Jill's wristwatch and frequently said how much he wished he had one like it. Jill decided to give Jack the watch for his birthday the following week. On the weekend before Jack's birthday, Jack and Jill attended a company picnic. Jill took her watch off and left it on a blanket when she went off to join in a badminton game. Jack strolled by, saw the watch on the blanket, and decided to steal it. He bent over and picked up the watch before he could pocket it. However, Jill returned when she saw Jack holding the watch. She said, "Jack, I know how much you like that watch. I was planning to give it to you for your birthday. Go ahead and take it now." Jack kept the watch. Jack has committed A. No crime. B. Embezzlement. C. Attempted larceny. D. Larceny. Before I release the answer with the reason, I am going to wait for you a little bit. Or you can pause the video if you need. Can you guess what the answer is? Alright, as you guess, the answer is D. Larceny. This is because Jack saw Jill's watch on the blanket, decided to steal it and picked it up. Note that even the slightest movement will satisfy this requirement. So Jack's act of picking up the watch is sufficient to satisfy all the elements of larceny. Alright, you want another question? Then, please hit the thumbs up and subscribe right now. Before we jump into the next question, let's learn the relevant rules. Robbery is larceny plus force or threat of immediate harm. If the defendant believes that the property is her property, the defendant is not guilty of larceny. Now we are going to read the next question. After being fired from her job, Melania drank almost a quart of vodka and decided to ride the bus home. While on the bus, she saw a briefcase. She mistakenly thought was her own, and began struggling with the passenger. Carrying the briefcase, Melania knocked the passenger to the floor, took the briefcase, and fled. Melania was arrested and charged with robbery. Melania should be A. Convicted, because mistake is no defense to robbery. B. Convicted, because her intoxication was voluntary. C. Acquitted, because her mistake negated the required specific intent. D. Acquitted, because she used no threats and was intoxicated. Before I release the answer with the reason, I am going to wait for you a little bit. Or you can pause the video if you need. Can you guess what the answer is? Alright, as you guess, the answer is C. Acquitted, because her mistake negated the required specific intent. This is because Melania mistakenly thought the passenger's briefcase was her own. Since Melania thought the briefcase was hers, Melania's mistake of fact negates the intent to permanently deprive element of robbery. One more question? Then, please hit the thumbs up and subscribe right now. Here we go. Jisoo wanted to make some money, so she decided to sell cocaine. She asked Min, who was reputed to have access to illegal drugs, to supply her with cocaine, so she could resell it. Min agreed and sold Jisoo a bag of white powder. Jisoo then repackaged the white powder into smaller containers and sold one to Jen, an undercover police officer, who promptly arrested Jisoo. Jisoo immediately confessed and said that Min was her supplier. Upon examination, the white powder was found not to be cocaine or any type of illegal substance. If Min knew the white powder was not cocaine but Jisoo believed it was, which of the following is correct? A. Min is not guilty of attempting to sell cocaine, but Jisoo is. B. Min is guilty of attempting to sell cocaine, but Jisoo is not. C. Neither Min nor Jisoo is guilty of attempting to sell cocaine. D. Both Min and Jisoo are guilty of attempting to sell cocaine. This time if you know the answer for this question, type your answer with the reason in the comment box below. I will leave the answer on my Instagram study 4 bars. Follow me on Instagram and check the correct answer of this question. I hope today's video was helpful to your bar study. If you want to study more for the UBE, don't forget to subscribe. Happy study!